Hi, I'm John Barry from Barry Law, and I want to give you a quick update on the Camp Lejeune Justice Act. You've probably heard about the elective option, which was recently announced by the Department of the Navy. There are two components to the elective option. The first is qualifying injuries by tier. There are two tiers of injuries. The second is duration of exposure. Now, there are a few things you need to know. First of all, if you do qualify, you do not have to take the elective option. The elective option is an option, and we will be reaching out to you to discuss whether taking this course of action is the best course of action for you and your family. Second, if one of your diseases or disabilities does not qualify, don't worry. The elective option only applies to some of the claims and not all of them. We will continue to litigate your case. Number three, if someone contacts you and says they're from the Department of the Navy and they want to talk about the elective option, it's fraud. The Department of the Navy will not be reaching out to you. All right, now let's get into the meat and potatoes of this. There are two components: the tier of injury, tier 1 and tier 2, and the duration of exposure. Let's just walk through one. So for example, if you had a tier 1 injury, like kidney cancer, and you were on Camp Lejeune for a time period between 30 and 364 days, you would be entitled to $150,000. If you had kidney cancer and you were on Camp Lejeune for 1 to 5 years, you would be entitled to a settlement of $300,000. Now keep in mind, whether this is a tier 1 or tier 2 injury, if it resulted in a wrongful death, there's an additional $100,000 added to your claim. Once again, if you are eligible for the elective option, we will be reaching out to you to discuss whether taking that option is the best course of action for you or your family. If you have immediate questions, please reach out to Cristina Hilker at this number. Thank you for your attention, and thank you for your service to this great nation.